So, welcome everyone. We're glad you've joined us here today. I have Lisa Gavin here, who's with us from Iowa Legal Aid. She is an attorney and is just going to give some information about Medicaid, and then there'll be time for questions if you have any. We're also hoping to be joined by Lori Gibson, who is from the Iowa Department of Human Services, and she works in I think waiver services. So she helps those that are applying for Medicaid to get through that process. So hopefully she'll be able to join us, but we will go ahead and start with Lisa. So thank you, Lisa.
Well, thank you. And hi, everybody. So I am the managing attorney of the Cedar Rapids office of Iowa Legal Aid, and we provide services in Lynn and 5 other counties. But Iowa Legal Aid is a statewide program where we serve all 99 counties in Iowa out of 10 regional offices. So even if we don't serve you out of the Cedar Rapids office, we do cover the entire state. So I was asked, or the part I was going to talk about is Medicaid financing for long-term care, generally nursing homes. What I generally tell people when I talk about this is a very complicated area of law, and I think you could take a semester class on this, and I'm going to give it to you in 45 minutes or so, so that I can share my time with Lori. We're a very small group, and so I think it helps if people ask questions as they have them, and I'll stop for breaks in between topics before we move on to make sure that I've answered people's questions. And I don't know how you want to do that, Angie, if you want to have them submit in chat, or I can just stop and then people can, jump in to ask questions since we're a small group.
I think whatever's easiest for those that are on. If you have a question and you want to throw it in chat, I'll pay attention and let Lisa know if something pops up. And I know we have a couple people on the phone here. So if you're on the phone, you're currently muted. I think you have to press star and then 6 to unmute yourself. And then you can just ask a question as we go along too.
Okay, and the first thing that I wanted to say is how you can contact Iowa Legal Aid if you have questions or if you need legal assistance in the future. If you are over the age of 60, we have a legal hotline for older Iowans, and that number, and I'm going to send you all this information so you don't have to write any of it down, but that number is 1-800-992-8161. You can also contact Iowa Legal Aid on our regular phone lines. We do intakes every day, except for Thursday afternoons. We do from 9 to 11 and 1:30 to 3:30. You also can go on our website and you are able to start an application that way from the website. And that's something you can do 24 hours a day, 7 days a week, 365 days a year. So that is 3 ways that you are able to contact Iowa Legal Aid if you would like assistance. So as I said, I have several packets that I normally hand out, and I will email them to Angie so that she can get them to all of you. I generally don't like to use a PowerPoint because honestly, I kind of wing these, and then with the PowerPoint, I end up reading, and so I don't think that is very entertaining for you. So the first thing about Medicaid eligibility for nursing home or long-term care, and if you take nothing else out of this presentation, is that when you are starting to think about nursing home or long-term care, that is the time to fill out the application for Medicaid. You want to do it as soon in the process as possible because there are income and asset limitations. But if you do this in the beginning of the process, you will know what assets have to be spent down and what assets can be kept by the community spouse. And it is a lot more generous than you think. It is designed to make sure that the community spouse is not impoverished, does not have to struggle. A lot of times people think they have to wait till all the money is gone, then they apply for Medicaid, and that is not the case. You want to know ahead of time so that you can do some strategic planning to protect both spouses. So if that's the only thing you take out of this, is you don't have to spend all your money first, and do this as early in the process as you can so that you know what has to be spent and what doesn't. People are generally pleasantly surprised. And that's always kind of a nice thing to find out. So I've just talked to so many sad cases where people are like, we've spent all our money. Now we've applied, now we're going to apply for Medicaid. And I'm like, oh no, because now the community spouse is going to have a harder time. So again, that's my main takeaway. But so let's talk about it. Income and assets for Medicaid eligibility. And I'm going to talk about the case where it is a married couple, because if it is a single person, it's very straightforward. You have your income, you have your assets, and you have to, spend it down to $2,000. It's the married couple that is the complicated part. So income. For income, Medicaid, or I'm just going to use DHS to stand for Medicaid determination. DHS is going to look at what the income is for each spouse. Each spouse gets to keep their own income. Okay, so the community spouse's income is not going to be counted in the Medicaid eligibility. So they're going to look at what the person going into the facility, what their income is. If their income is below, sorry, I couldn't get these numbers memorized. If their income is below $2,382 a month, the person is automatically income eligible for the Medicaid. However, we all know that nursing homes cost significantly more than $2,382. So people are going to still need assistance. So what was created is a document called a Miller Trust. I like to think of this as partial Medicaid. Okay, so this is for people who are over income to automatically qualify, but don't have enough income to apply to be able to pay for nursing home care on their own. So this is for people between $2,382 a month and $6,584 a month. And what happens is that you can create a trust document, and the money, your monthly income, goes into this trust each month. So you don't have access to it. You get $50 out of it, which is what is allowed for personal expenses, which has been that amount since I started practicing in the mid-90s. So it is what it is. It's $50. And then the trustee, the person who's managing the trust, gets $10 a month. Everything else is paid to the nursing home facility, and then the remainder is paid by Medicaid. So that allows people who are over income for automatic eligibility, but not able to pay their own, to get some help from Medicaid to pay for the nursing home. So this was a really nice thing when it was created, because it used to be a cliff and people would be over income for Medicaid, but in no way able to pay for nursing home. So this is a good document. This is something that Iowa Legal Aid is able to help people with. It sounds complicated, but most, it's generally a form that needs to be completed, someone willing to be the trustor, and it just needs to be approved. DHS has basically a form. You fill it out, then you send it to them for approval. And if you did it correctly, they approve it. And if you didn't, they have you make changes and then it gets approved. So it sounds more complicated than it is, but that will allow people to be eligible for Medicaid. If you're over the 6,584, then you are private paying for Medicaid, as long. And again, that's only the spouse that's going into the nursing home whose income is counted. So if both spouses receive $1,600 a month in Social Security, the person would be automatically eligible because their income is $1,600. Does anybody have questions on that so far? Excellent, because that's the easy part. Now we're gonna fall off the cliff a little bit on some things, but so now we're gonna talk about asset and resource limitations. Generally, for Medicaid, you have to have resources less than $2,000 to be eligible for Medicaid. So that is not a lot. So how DHS is going to determine your assets in this situation is they are going to take assets that belong to both spouses. So it doesn't matter how it's titled or who owns it or what. Anything owned by both spouses is thrown into a community pot. Okay, so we throw everything in the pot: the house, the car, insurance policies, your furniture, money in the bank, all of that gets thrown in the pot. Then you get to take out certain assets which are exempt under the law. So you get to pull out the house. You get to pull out one car. You get to pull out all your household furnishings, and you get to pull out any prepaid burial plans. So all of that comes out of the pot. For most people, that pretty much depletes their pot. They don't have a lot in there once you pull all those things out. But what DHS will do is anything in the pot, they will divide 1/2 to the spouse going into the nursing home and 1/2 to the spouse that's staying in the community. Okay. And to be eligible for Medicaid, the spouse going into the nursing home has to spend down any of their resources so that it's $2,000 or less. Okay. So I'm going to give you an example of this. So we have two people, husband and wife are both 85. They both get $1,000 a month in Social Security. Husband is applying for Medicaid. Husband is income eligible because his income is $1,000. It's $1,000. So it's less than the $2,385. They also have a home that has equity of $140,000, a car worth $10,000, and the husband has $40,000 in savings in the bank, and the wife has $50,000 of savings in the bank. We're not going to query how they were able to raise this much money on $2,000 a month, but that's what they have. They've obviously been good savers. So what happens is we put the house, the car, and the bank accounts in the pot. Then we get to pull the house out because that's going to go to the wife because she's still going to be able to live there. We're also going to pull the car out because she's going to be able to keep the car. Then we have $90,000 in savings. And that is not exempt because that's just liquid cash, We're going to divide that in half. Wife is going to get to keep $45,000. See, this is why you want to do this early, because you don't want her to have spent that money already, because she gets to keep $45,000. The husband gets $45,000. So he's going to be over resourced, and he's going to have to spend down the $43,000 to get down to $2,000 to be able to be eligible for Medicaid. Does that make sense to everybody? Anybody have any questions?
It does. Question I have, and maybe you're going to lead up to that. How do you can actually plan for that? Let's say things are deteriorating health-wise slowly, and at some point in the future, you anticipate one of the spouses needing to go to a nursing home. How far in advance can you actually pre-plan to get to that level where you're eligible?
You can, yes, you're exactly right. There's going to be pre-planning so that you can get there. And I'm going to tell you some things that you can do, because these are things that you can do, at any point, or you can wait and do it after DHS tells you what the allocations are. How you can spend down this money is there's a lot of very good ways that you can do that. You can basically pay off any of your debts that are owed by either spouse. You can buy prepaid funeral plans for both spouses. You can buy exempt assets. So, a car, furniture, things that the community spouse is going to need to live. You can also buy things for the spouse that's going to be in the facility. This is where, TVs, maybe stock up on some of their comfort care items because they're only going to get $50 a month in the future. Buy comfortable furniture, buy comfortable, maybe if they need medical devices, anything that would make their life better. In the medical facility, you are able to spend down the money to buy those things. And it doesn't have to be medically necessary. It can be a TV, it can be a computer, it can be any of those things that will give their life, more enjoyment.
So you could so if you thought in the next 2 years, for example, that one spouse would need to probably be in a nursing home, and the spouse that the health is still okay, you could, but the car they've got is 10 years old, and that's going to wear out. You could buy a car for the one that's not going to the nursing home, so that you've got a vehicle that's going to last and be reliable.
Yep. You can buy a car, buy furniture. You can repair or remodel the house. You can pay down the mortgage so they don't have that bill anymore. You can, let's see what else. Anything that will benefit either spouse. You also, it says in there, can the community spouse can go on vacation and use that money for a trip. I mean, there are, anything that would benefit them, you're allowed to do.
You mean the spouse that doesn't need the care could go on a trip and use that money?
Yep.
Oh, interesting.
I know, but it's listed there as an example, so it's good.
Well, perhaps when the law was written, you know that the other spouse has been very, very worn down by the care they provide, and they might need
Yes.
they might need a respite of a week or two somewhere where it's warm to recharge the batteries.
Exactly. Having going through this in my family, yes, my stepmother will definitely need a vacation to recharge the battery after the caretaking she's doing on a daily basis, especially in COVID when none of us can help as much. But yes,
How
so
far back? How far back then do they? When you make your application, how far back do they? From the point in time that the Medicaid is approved, how far back do they go as far as getting copies of bank statements to kind of see what kind of liquid assets were in a bank? Do they go back 2 years or 3 years or how?
we're gonna get to that in a minute. You are
okay.
following. No, you're doing a good job. You're following along on my outline. I think you've taken a sneak preview of my non-existent PowerPoint.
I was hoping I wasn't out of line and I was asking appropriate questions.
You are right on target. So I just want to make sure that everybody is on that we're kind of closing out the how you can spend down your resources. So in that hypothetical when I gave you where the husband is going to have to spend $43,000 to become resource eligible for Medicaid, that money can be used to pay the mortgage on the house. It can be used to buy him some furniture and, a TV, things like that for the nursing home. If there's something that needs repair on the house, they can do that. So there are some pretty beneficial ways that they can spend that $43,000 down to be able to provide what is needed for both spouses. Now, sometimes people have a lot of money, and so we're talking money that, they're not really going to be able, once they do all of that, there's still money left over. What happens then is the money gets used to private pay for the nursing home until they get down below 2,000. But I did want people to understand that that's not the only way you can spend the money down is by private paying for the nursing home. You can also spend that money down in ways that will benefit both spouses and make their life better. And DHS, when you apply, and will give you more guidance and more suggestions on how that money can be used. Does anybody else have any questions on the allocation and spending down money?
So just to review that quickly, like you had mentioned, let's say the couple in accounts had $100,000 in the bank. Half of it would be half of it would go to the person that needs to go to a long-term care facility, and then that $50,000 is what would need to be paid down to less than $2,000.
Yes.
In some paid down in some legitimate way down to that $2,000. Okay. The other $50,000 would not have to be spent or in any other or planned for in any other way. That would just be owned by that spouse that does not go to the facility.
Yes.
Okay.
Yep. So that's why my main stress on this is that people find out whose money goes where and they get a resource allocation, so they're not spending down more money than they have to, because we want that community spouse to be able to maintain their lifestyle. And if they're only getting, and they're going to lose one half of their, and sometimes one half, 2/3 of their income when that other spouse goes into the nursing home. So, I mean, this woman's only going to have $1,000 to live on. And so she's going to need that money in savings to help subsidize, her ability to make her payments and things like that. And so, and that's what the purpose of this is, not to impoverish that community spouse. So, I
Lisa,
mean,
I have a
yes.
question for you. So, I've worked with a caregiver before who was concerned because she had never worked in her life, and so she had, little to no income coming in, and her spouse, the one who needed to be placed somewhere, was the one with all of the income coming in each month. Is there
Mhm.
something that Medicaid looks at to transfer income potentially to the community spouse?
Yeah, in that scenario, there are some things that DHS will look at.
Mhm.
And one of that is how they distribute some of the assets and things like that to make sure that that spouse, that gets really complicated
Yeah.
and it might get a little bit beyond the scope of this.
No,
But
that's fine. I just wanted to make
yeah,
sure that that was something, one, that actually can happen, and then two, I
I'm
think,
not sure about transferring income, but I know definitely transferring assets.
yeah,
I mean, in some scenarios, this is gonna not be good for the community spouse. I mean, if there wasn't a lot of money before,
mhm,
things could be fairly tight. But I mean, they will make sure at least that the community spouse has up to the SSI amount.
okay, good to know.
Cause
Thank you.
yeah, which is not a lot to live on. We all know that, so. Okay.
Abby had a good, Abby, you might not be done yet. You might have, are you done answering your question, Abby?
I think so. Rick, did you have a follow-up to that?
I didn't want to interrupt you if you
No,
were.
you're fine. Go ahead.
I just wanted to clarify that, make sure that I understand. So the community spouse is the one that is going to be living at home, and when you say community spouse, that's the one that's going to be living at home. The other spouse is the one going to the nursing home, correct?
Yes.
Okay, so in an example, let's say the community spouse had I guess income of $2,000 a month, and the one going into the nursing home had income of $1,000 a month. So that community spouse's income doesn't have to be taken into consideration. It would be the person. Is that right?
Yes, it's only for income. It's only the income attributable to the person going into the nursing home that counts.
And that's the money that would go into that Miller trust.
Only the mill, yes, but only if a Miller trust is needed. A Miller trust is not needed in all cases.
Okay.
So I will give you back a couple examples. So let's say the person going into the nursing home is gets $1,000 a month, so I can keep my math equal. But the person, the community spouse is younger and still works full time and makes $100,000 a month. The only income they're gonna look at for purposes of Medicaid is the spouse going into the facility.
Okay, I see.
Okay. But in that scenario, they probably wouldn't be looking at Medicaid because they may want to go to a nicer care facility than what you can get on Medicaid. You know what I mean? And there's be a lot of resource issues, but then it can also happen in the reverse. If the spouse going into the nursing home has more money, that can make it tough. It may be the spouse in the community is going to lose that income.
Okay.
And so the only time you would need a Miller trust is if the spouse going into the nursing home receives more than $2,500 and less than $6,500. In that kind of area, then you would need a Miller trust. So really poor and really enriched people do not need Miller Trust, it happens a lot with the middle class. Like if you have a stream of income, maybe you're maxing out Social Security and then you have a pension, that generally puts people in Miller Trust land. But if you're just on Social Security, you're not going to need a Miller Trust. And then if you have tons and tons of pensions and 401ks and all of that, you're going to be over income. So the question that you had, which was a good one, and this is the one that scares people, but it doesn't have to. And this is, what is that look back period? So when you apply for Medicaid, DHS is going to look back 5 years, 60 months. What they're going to look back at is how you spent your money, not how you spent your money, but what kinds of transfers of assets that you did. Okay. They're going to look at if you transferred assets for less than fair market value, or if you made large gifts of money, including charitable deductions, to divest yourself of resources with the intent of becoming Medicaid eligible. Okay. So, and all of this stuff comes because of bad actors. Okay. Most people do not have any problem with this. When you look at what you've done, it's all going to be fine. And most people do this with the advice of a probate or estate lawyer, because as people start to age and they want to make sure that they have clear directions on how they want their resources and money to go when they pass away, they will contact an estate and probate attorney for some help and guidance with this. One of the things that all estate attorneys look at is if it's feasible that the person will be going or could go into a nursing home within the next 5 years, your estate and probate attorney will help you plan for that and make sure that you do it correctly. The reason I know this is when I was a baby attorney and I had just graduated, they had changed the law on this. So about 95, 96, and they put criminal penalties on the lawyer who helps people dispose of assets to become Medicaid eligible. So if an attorney helps you to become Medicaid eligible and does it in violation of the DHS rules, the attorney is the one who could go to jail for this. So I think all probate attorneys are not willing to go to jail for their clients. So they are going to give you very good advice on your estate planning and contemplating potential Medicaid. So basically, it's not that you can't live your life and conduct financial things. You just can't get rid of assets for less than fair market value or give large gifts. It's basically what I would say is the smell test. If it doesn't sound right and it looks and smells bad, that's when you're going to have problems. So if you do a quitclaim deed of your farm to your son for $1, that doesn't smell good.
Yeah,
That's
that
gonna,
doesn't smell good at all. That doesn't smell good at
right,
all. The son
right.
might be happy.
That's going to trigger
Yeah.
an investigation if it happened within 60 months of you applying for Medicaid. If you're a generous grandpa and you normally give $500 to all your grandkids for Christmas and you keep doing that, that's not going to raise a stink. If you all of a sudden are like, guess what? It's going to be a great Christmas and everyone's going to get $25,000 from grandpa. So grandpa can divest his savings. That's going to smell bad. Because
How
that's
about
going
if,
to,
oh, go ahead. Go ahead. I'm interrupting.
yeah. I mean, you can give gifts, but if you're not historically the kind of grandpa that gives $25,000 at Christmas, that kind of thing is going to trigger a look. Okay.
How about if the gift was within the IRS gifting limitations? I think it's, if I remember right, it's 15,000 a year right now for one grandchild.
That's not going to factor in for Medicaid eligibility. What they're looking at is, are you giving gifts to divest yourself of money?
Oh, like a farm or
Yeah, like a
50,000.
farm, or if that one family, that we talked about in the hypothetical, if they had their 90,000 and they decided to give everybody a big gift at Christmas, and now
I see.
suddenly they have zero in their account, that's what they look at. Those
So the regular gifting allowed by the IRS within those limitations would be okay.
It depends. The IRS, this is two different federal programs, and they got two different things that they're looking at there. So what you can do for tax purposes is different than what you can do regarding the look back period and transfer of assets.
Okay.
So think of them as separate, okay?
Okay.
And this is something, the more complex your estate is, the more that kind of things, you're going to want an attorney's guidance as you're planning this. I mean,
Yeah.
there's attorneys all over that this is what they do. And they know the DHS rules about Medicaid eligibility, and they're going to steer a clear path for you, because they're not going to help you do something shady because they don't want to go to prison. Okay. So they basically are going to just look back at the last 60 months to see if anything causes them to have a smell test. 99.9% of people just sail through this provision without any problems. The people who don't are the people who try to play a little too cute with the rules. And those people know what they're doing. You know what I mean? So, or sometimes people aren't very sophisticated and they don't think about it. We've had a couple clients who have not really thought about it, and then just added the name of a child or added the name of somebody else because they didn't want to have to go through probate. And sometimes they're not thinking long term on this, but no lawyer would help you do that. If you're 75, you go to a probate attorney and say, we'd like to do a quick claim deed, add my son's name to the house and take my name off and do it for the traditional $1. The attorney is going to be like, whoa, you're 75. You could have something happen to you where you're looking at Medicaid, applying for Medicaid for nursing home in the next 5 years. I ain't helping you do this because I could go to jail. So, yeah. Yep. And like I said, most people, this is not even an issue. You're just living your life and, not doing crazy things that smell bad and look like they could be quasi illegal. And so you're fine. There are some exceptions to this where the 5-year transfer for less than fair market value will not hurt you. And those I'm going to go over with you. Those are if you give the property to your spouse, okay? You can give it to your spouse for less than fair market value, i.e. take your name off of it and just have your spouse's name on it. You can transfer any asset to a disabled child. So if you're trying to make plans for a disabled child who is going to outlive you, that is something you're able to do. You also can, if you have a child, and they say child, but it's an adult who lived with you and provided care to you for 2 years, and that care kept you out of the nursing home, then you're able to transfer that house to that child. This is all things people are going to want to do with the guidance of an attorney, to make sure everything is being done correctly and legally. But those are your exceptions: spouse, disabled child, and a child who took care of you and kept you out of the nursing home. You're going to be able to reward that child, I guess, for what they did. And that's going to be completely fact-based. So you're definitely going to want to have a lawyer on that one.
So you could put, you could maybe, the assets, your basic, some savings and checking put into the name only of the community spouse. Would that money?
Yes, yeah. Well, yes, because it's not going to matter in the long run, because all that money's going to come back into the pot.
Okay, so
remember, back when they look at your resources, it doesn't matter how it's titled, they bring it all in.
So even any account that's only in the name of the community spouse, that also goes back into the pot.
Yep.
Gotcha. Okay.
Yeah. So what happens if they find that you violated the rules and sometime within the 5 years you gave something for less than fair market value and you shouldn't have? There's going to be 2 things they're going to do. One is they're going to try to pull that asset back from the person who got it. What they're going to do if you ran afoul of this rule is they're either going to look at the person who got the asset for less than fair market value, and they're going to pull it back if they can, which means say, hey, you got paid $30,000 and you shouldn't, give us it back. Or they're going to assess a penalty against the person who did the transfers and their eligibility for Medicaid help. So let's say, and I'm using round numbers because I can't do math. Let's say that you gave $10,000 to your kid and DHS finds that was not okay. Then they're going to look at, we're going to say the average, what your penalty is going to be is based on how much you gave away and what the average care of nursing home care is in Iowa. So we're going to say $5,000. And so they're going to say, okay, you gave $10,000 away. So we're going to figure out how many months you are by how much nursing home care would be. So that 5,000 fits into 10,000 twice. So you're going to have 2 months where we're not going to pay Medicaid to penalize you for giving the 10,000 away. If you had given 100,000 away wrongfully, then they're going to say, well, 5,000 a month, that's 20 months where you're not going to get Medicaid that you may otherwise be entitled to. So that's what they do to penalize people when they figure out that they did a wrong transfer. There is an exception, though, if it would create a life-threatening hardship for the person. Like, let's say they're very, very disabled. There's no one to care for them. They gave the money to someone who's long gone. and there's no one to care for them, and they wouldn't be able to live on their own, you know, and safely. So there is some exceptions, but as a general rule, that's what the penalty is for that 5-year look back. Now, if you did everything 62 months, if 62 months you did a whole bunch of shenanigans, but they only look back 60 months, you're fine. But I will tell you, lawyers helping you to do this are going to look at your age, and they're going to look at the likelihood that you could end up in a nursing home. So if you come in and want to do a lot of shenanigans at 35, they're not going to trip a red flag that you're going to be in the nursing home within 5 years. But if you come in at 65, they're probably not going to let you do those same shenanigans, because it looks then like you're doing it for purposes of Medicaid eligibility. Now, that was a lot. And usually when I talk to a classroom of people, we have a lot of questions. I know we got a small group here, so I don't know if people have questions on that.
There's someone on the phone that unmuted themselves, the 515 number. Did you have a question?
And Lisa, thank you for your presentation today. Are you able to hear me?
Yes.
Yeah, we can.
Okay.
Go ahead, Ed.
Okay. My question is this: I'm calling in for my father, who's currently in assisted living, and he'll be eventually moving to nursing home care. And my question is, he has an asset. Dad is a widower, so there's no spouse in this equation. But he has an asset that's entitled with a joint heir, jointly with my sibling, my brother. How would they handle an asset like that as far as the amount? Would it all go to Dad? Would they consider half of it goes to my sibling, his son? I'm not sure how to handle that situation.
That one is obviously a lot more complicated because it's not a spousal situation.
Mm-hmm.
I cannot 100% tell you how they will handle that. I'm not trying to punt that, but I don't necessarily know the answer, because that's not usually the circumstance that we deal with. But that would be something. Is he looking at going to the nursing home soon, or?
We're in the process of making an application, in the next few months. So.
Okay. I mean, DHS is going to be able to tell you what they're going to want to have happen with that asset. Like what's going to be attributable to your dad. Yeah, I don't want to steer you wrong, okay?
No, I appreciate that. Thank you.
Okay.
Ed, if it's helpful to you, I don't think Lori was able to join us today. She's from DHS, but I can shoot her an email and just see if she would be able to call you to follow up too. Does that sound like it would be helpful?
Oh, no, that's fine. I'll go ahead and contact DHS myself. I'm
Okay.
over in the Des Moines area, so we'll do that.
Okay. Well, let us know if you'd like. We can definitely do that.
Thank you again.
Okay, I don't know where we are for time, but I do have an issue, one last topic. And this one also sometimes gives people a lot of questions and some concerns. And this is Iowa's Estate Recovery Act. And so this is for and applies to people who receive Medicaid for nursing home care. Not all Medicaid users fall under the estate recovery law. So that's important to know, because there's a lot of people who receive Medicaid because maybe they have low income employment, they're on SSI, they're eligible for it as children. So those Medicaid users do not fall under this act. It is for money that is spent by the state in Medicaid dollars to pay for long-term care. And so what happens is basically the state is like, we helped you to pay for someone in the nursing home, and now that they have passed away, we are going to want to collect as much of the money that we spent as we can from the assets of the person who passed away, who was in the facility. Okay. And so generally, the state is able to do that. Usually it goes as a lien against any property, generally real estate, that the person owned. And when the estate then puts the house for sale, they will collect on their lien from the sale of the property. So it's basically saying to heirs, you can't have us pay for your parents' nursing home care and also get their assets free and clear. At some point, you're going to have to pay the piper. But there are several exceptions. One is if there is a community spouse or a spouse who's living in the house, they can continue to live in the house until their death and basically delay the estate recovery. The state will not make them move, will not make them sell the property to pay off the debt. As long as it's a community spouse living in the house, they can stay there until their death. If they go to sell the property, then the estate recovery may kick in. The other thing is if there are minor children under the age of 21 living in the house, they can stay in the house until their 21st birthday, and then the property would need to be sold if the adult they're living with is not the spouse of the person. The other thing is if there's an adult disabled child, that child is able to live in the house until their death before the estate recovery would kick in. So for example, I represented a guy who was in his 90s, and he had received, and this also applies if you receive waiver services. So he had received waiver services for like 20 years, and he owed like $500,000 in Medicaid assistance that he had received. But his son was 75 and disabled and lived with him. So when my client, the 95-year-old guy, died, his son was able to remain in the house and still lives in the house now, but he can remain in the house until he passes away and not have estate recovery apply. Also, they owed like $500,000, but the house and the assets in the estate were only going to be like $140,000. They weren't going to come personally after the son. They were going to accept what they got from the sale of the property. So, I mean, that's a good benefit because it prevents community spouses and disabled children from becoming homeless upon the death of a parent or a spouse. Does anybody have questions on estate recovery?
I don't know if anyone else has any questions. I know we're coming up on our time here. Or if Lisa, if you wanted to share anything else moving forward and last thoughts.
Yeah, just that I think kind of to follow up what everything's been said is like, this could be a semester class. We did it in an hour. So there's a lot of things, and I hit main points, and there will be a lot of things that pop up in specific circumstances that, again, we could have gone all over the place on this. So the thing is, apply early, find out what that resource allocation is going to be. And then, you know, I think definitely estate planning and talking with the lawyer is a good idea. It does not have to be Iowa Legal Aid. There are lots of attorneys who do estate and probate work that will send you, you know, in very good directions on this. So.
We have a list here of attorneys that caregivers have used and found helpful. Iowa Legal Aid's also on that list, but if any of you caregivers are looking for someone who does estate planning, you definitely can let us know. The other thing is we help people too with Medicaid applications. So if you're someone who wants to get started on that, we can work on it here or connect you with someone like Heritage Area Agency on Aging to get started with that as well. I think, Lisa, there was one other question that I had that I wasn't sure if it would be meaningful for this group, but I know sometimes people that I've talked to who are spouses start to think that maybe divorce is something that they have to look into. Is that something that you hear often with people trying to apply for Medicaid?
Not anymore, since they have created a lot more protections for community spouses. I know maybe 20 years ago, that was more of an issue. I think you need to be careful on doing things like that that could look fraudulent and trying to make yourself eligible for Medicaid. You know, if I would say if you don't want to get divorced, don't get divorced. It may create a lot of other problems for you, especially if you are still wanting to caretake and make decisions for your spouse. And you don't want to look like you're doing this for the purpose of Medicaid eligibility. And I think that there's not really a need to do that anymore with the protections that are put in place for community spouses, because in a divorce, you're going to lose resources too. You know what I mean? I don't think it will be advantageous to you.
Okay.
And it could be very disadvantageous to you if they think you're doing fraudulent, doesn't pass the smell test, could get you in a lot more trouble. No one wants to go to jail for Medicaid fraud.
Definitely not. Thank you for that. Anyone else on the line that has questions?
I have a question. In regards to divorce, I'm going to speak pretty bluntly here. I think that my parents should probably have gotten divorced probably 20 or 30 years ago. And I think that my mom, who has dementia now, she's kind of lost her filter at this point. And so a lot of these things are becoming more evident. And it's not just her, it's the people that she's confided in over the years, echoing the same sentiments about how unhappy she's been in her marriage for a very long time, and how all these things have been happening that both neither my sister nor I were really privy to until recently. If we were to need to move forward with a divorce on completely legitimate terms, can you offer any suggestions or advice on the best way to navigate that, or some things to consider?
A lot of it is how you proceed is going to depend on the level of competency that your mom has. Is she able to, it's going to depend on, is she know what's happening? Is she able to direct the litigation so that, it would be filed in her name rather than on her behalf? I have never, and just because I haven't doesn't mean that it's not done, but I have never filed a divorce on behalf of someone who is not competent to make legal decisions. I think then at that point, somebody in the family would be acting more in the role of a guardian for her. And, a lot would be done based on what's in her best interest, if that makes sense.
Yeah, it does.
And the level for, legal competency is that she would know what she's doing and understand the options and the consequences from the decision that she makes. And I know I have a father with dementia that sometimes that varies from day to day.
Any other questions that people have or things you're thinking about? I know all of our situations are unique and complex, so I can only imagine the situations Iowa Legal Aid faces daily.
Very similar, I think, to what people see, you know, in their own. Because I thought I kind of understood it. And then it's happening with my dad, and it's a lot different as the child than the lawyer on what are the best decisions. I'm a lot more confident on what are the best decisions as a lawyer than I am as a daughter.
Yeah, it definitely makes you see it differently when you're going through it yourself.
Yes.
Yeah. Well, if there are no further questions, then I would like to thank Lisa for her time today. I'm so sorry that Lori couldn't join us, but hopefully we do these quarterly. So if you guys have any questions, you know, moving forward, let us know. We can reach out to Lisa or Lori. But otherwise, if you have questions in the meantime, you can see us again in a couple months. And thanks again, Lisa.
All right. I can't wait till we're back in person.
I know, yes, that would be lovely. It's a little weird over Zoom, so I appreciate all of your patience.
All right. Thank you for
Thank you
having me.
both.